look. Hey,
I'm approaching on David Crumpholz Padilla, and have you had a chance to look at the TRAS? Okay. So in Brazos County, I actually just moved from there 6 months ago. They don't file cases right away. So he was arrested on the 28th. I think they got his blood. So in my experience, it may take 4 or 5 months before they file it. Sometimes longer, sometimes shorter. So
what are you suggesting?
I think that
He needs help.
He does need help.
He needs help. There's no doubt about it.
I think
he's blacking out. He's memory loss due to alcohol. He's injuring himself because of alcohol. Can't stop. So it's a cry for help. So I want him to get help. But what they're suggesting is inpatient, outpatient. So what we'll do is I will give him the opportunity and I'm going to tell him, you muck it up. Next time it's going inpatient and that's it. Do you mind bringing him out? So let's extend it for a year. Where's he living now?
He lives in the Woodlands now.
Okay.
He has family here, actually in court. So I don't.
It's here.
His mother is here.
Oh, great. Come up. Wonderful. I'm so happy you're here. Yay. Are you dad? Stepdad. I'm so happy you're here. This is great. I'm going to bring him out now. And I got to say, I'm happy that you didn't bond him out. Great. He needs to learn that it's not a joke. And I think that so far he's been taking it as a joke. So essentially what we did was I had him evaluated to see what's going on in his life, what he's doing, where he's going. It's not gone well, ninth grade education, got his GED, which is great, but it looks like it's just gone downhill. Coming up, Mr. Crumpholz.
I need to slide this.
Guys, if you go that.
No, family.
No, you can't.
Come on around.
Okay, it's a security
I need
issue.
to this way for me.
That way.
Counselor, I need you. Step this way. There you go. All right.
So the deal is this, is that the alcohol is kind of ravaged him. We have self-destructive behavior. We've got memory loss, blackouts. From what is reported, wants to stop but can't stop kind of thing. The report says and indicates that you are to do intensive outpatient treatment program followed by supportive outpatient treatment program. I want to give you the chance to do this, Mr. Crumpholz, but I want you to understand that I'm not playing games. And that's why you are now still sitting in orange. And I'm not going to play this game with you again. I will give you but one opportunity to try to do this on your own. And if you're incapable of stopping, if you're incapable of doing it on your own, then I'm going to put you into an inpatient treatment facility. It's going to happen. It's whether are you going to be able to do it on your own? If not, then we're going to do it my way. And you're not going to like the way that I do it. But it's going to happen one way or the other. And I can extend you for the next 3 years. And I'll do it in a heartbeat to make sure that you're clean and sober. Not only does he have the case with us, but he has another one in another county. I don't know. Have you spoken to Mr. Elick yet? Okay. The problem is this, is that how are you going to pay for it?
How's he going to pay for it?
Because while he's in custody, I can pay for things. When he's out of custody, I can't pay for it. And I'll tell you, the intensive outpatient is around $500 to $600. How are you going to pay for this, Mr. Crumpholz? When is the last time you've had a job?
I haven't had work in about a month, but
beforehand.
Landscaping, like I said. Landscaping, like I said, Your Honor. And around this time is when I start doing Christmas lights. Well, my stepdad does the same thing, but I kind of learned from him, so I typically do it around the season.
There's no greater role model than a dad or a mom, really.
Think you'll be able to pick up enough business to pay for,
Yes, Your Honor.
you know, pay for this?
Do you think he'll qualify for TAP funding?
I'm not sure what he reported to the probation officer, but he will another financial affidavit and see if he qualifies for that.
Okay, we're gonna have you do an affidavit, financial affidavit in hopes that you can qualify so that we can pay for it for you. If I can't, I want to pay for it for you. If I can, I will. That way you don't have to worry because money is an additional stress that we don't need. I want him to have a device though. Okay, yeah, I want you to have a device so that I know that you're not consuming alcohol. If the one time you consume alcohol, you will get another warrant and you will stay with me this time. And I'm going to tell you now, the treatment facility, the program is a minimum 6 to 8 months if you respond well to treatment. If not, you could be potentially there for a year and a half in a treatment facility. Do you understand? It's going to happen one way or the other. That's it. So once he's released, must have a job within 30 days. So you have your own company, or what about?
Pressure washing, exterior cleaning. We do Christmas lights about this time.
What about Mr. Krumpholz working?
So we don't have the work right now. I have 2 employees currently. It just wouldn't be fair to.
No, and I'm not asking you to do anything that would, okay,
But I have told David that in fact, for example, we have 2 weeks of parking lot striping coming up next week that, you know, I would like him to be there. He's an amazing, amazing worker when his head is in the game. When the emotions, all those things get involved.
it's a great sign.
It gets a little more difficult, but
That's the idea. You got to understand that this life, this life is a journey, Mr. Krumpholz. And I'm going to tell you now, how old are you? You're 22. If you don't have any money, your life really is going to suck. Really, really bad. The divorce rate is so high in this country because of one reason. No one has money. And when you don't have money, what happens? You start fighting. And when you fight, what happens? And it's a cyclical process. It's over and over and over. People fight. They have no money. They have no education. They have no way of getting money. And they can't buy anything. And then they end up getting divorced. You set yourself up now and you work your ass now so that when you're in your 40s, 50s, and 60s, you have money. You can go on fabulous vacation, fabulous trips. You can buy a Jaguar, go to, a Michelin star restaurant. Landscaping, you will have a very tough life. Unless you're able to have some kind of extravagant, really kick-ass business.
I put a lot of work into it. I'm very creative and it's something I do like to do. I slacked. I haven't been doing what I was supposed to do.
It starts with one thing, a clear head. And as he said, you're an amazing worker when you have a clear head. That's all it takes. Mind over matter. That's what it's about. So I will give you this opportunity. It's the last time. I'm not going to do this again. You test positive again. You pick up a new case. I will keep you with me for a very long time. Do you guys have anything you'd like to add or state?
His name is David. And just like David, he was an amazing, had a big heart. My son has a big heart, and he had to go through this discipline as well. And I do believe that when David decides to honor God and surrender himself to God, there's going to be a lot of things that will happen for him. But he needs to start with him wanting to be better.
When you get out of here, where are you going?
Probably back to my grandma's house.
So that's what I'm getting at, I'd like to do that. And there's a couple of things that I'd like to do. I want to give him a curfew because I don't think anything good will happen in the middle of the night. I don't want you out in the middle of the night because there's nothing good that happens at 2 a.m. And I don't want you out. I want you to stay with mom so that she knows where you're going at all times. And I want you to either faithfully work or get back into school full time. If it were me, I would have you get back into school because the more education you get, it correlates the more money you make in life. That's it. You know, in life, if something was easy, everybody would be doing it. No, it's very, very difficult to be a doctor. That's why they make so much. If it was easy, everybody would be doing it. Landscaping is an easy thing. That's why it's so difficult to make a lot of money in it. But if you get into school, get a great education, and you learn something that not many people know about, sky's the limit. I use this example a lot, and I know I got a lot of people waiting, but I have a friend of mine who, you know, we all made fun of because he worked at Chick-fil-A, right? But he really liked it, and he did really well at it. He started, you know, washing dishes at Chick-fil-A. He now owns 2 Chick-fil-A's, and he's making $400,000 a year, running 2 of the most successful Chick-fil-A's here in this county. Sick money he's making a year. He put his heart, put his soul into it. God, this guy's a limit. That's what's great about this country. That's what you need. And that's what's going to happen. And if not, you stay with me. You understand? So for the time being, you live with mom, you've got a curfew, job within 30 days. Let's get the TAP funding and then IOP, SOP. And then, so the other thing is that he's got the case in the other county. I don't want him traveling other than having to deal with the case in that county as well.
Which device do you want me to get, the alcohol device?
The cheapest one, probably the portable device. If you ever have any questions, if you ever have any issues, you know where to find me. I can always help you. If you see him slipping up, just let me know or let Mr. Elick know, and we'll do everything we can to help him. If you ever have any issues, call us, stop by, send me an email. I'm happy to help you in any way. We have another guy that reached out to me yesterday, is having issues, right? So email me and we're doing what we can to try to help him. So that's what it's about. You got to communicate with us and we'll help you. All right? Okay.
Your Honor, I do have a question. Will
Sure.
there be PO reporting?
Every month. Absolutely.
Testing and things like that?
Absolutely. I'm putting a device on him so I know that he's not consuming alcohol. He's going to have to blow into this device daily to prove to me he's not consuming alcohol. He's also going to have to take, you know, weekly drug tests so that we know he's not, no marijuana, no mushrooms, no, nothing. You're not, no illegal drugs. You should be clean right now. Good. The next time I test you, if you test positive for marijuana, guess what happens? Right. It's not hard. Mind over matter. Okay.
Thank you, sir.
Thank you for coming. All right. Good luck.
Hey everybody, welcome to American Courts. Looks like we got a lively crowd in the chat tonight. Micah, you're showing your age on that on the pizza thing. I can't think of the last time that they ordered pizza with your phone number, but it did bring back the memories of ordering pizza with your phone number, where they'd show up and, you know, almost bullied you into paying for it because, hey, someone called from that number. But I think everything's got apps now. Hey Gina, I really enjoy Gina on here, and I enjoy everybody, but I especially enjoy Gina because she's always asking questions about the actual hearing and stuff like that's going on. I just want to let you know how much I appreciate you. I realize I got the best mods. I've seen other shows. I'm really not a comments person, but looking at here, it makes it just obvious how good our mods are. Thank you, everyone. Victoria, I'm trying something different without the headphones. I'm going to see if it works. I don't know how it's going to work. I don't even know if y'all can hear me, but we are definitely going to try. But yep, Micah, we are old. We are old. When you were saying that, it was reminding me of the days, I think maybe early 2000s when they stopped that. I don't know. We're going to have to explain to Linus what pizza is. I don't even know if they have that over there. I guess they do. Maybe in Italy they do. I don't know. It just seems like in the Netherlands, you just go out in the field and pick your dinner for the night. And so, all right, well, we are going to go to, we got a good Judge Middleton one. I like it, but we've got Judge Ricky, Judge Middleton, Judge Rosie, Judge Simpson, and of course we got today's Judge Fleischer. So thank you, Shirley. Thank you so much for that. I really appreciate it. We're always looking for ways to get better. I'm seriously reach out to me though. One, I've got someone who'd love to talk to you about your podcast, and two, I've got a bunch of questions about it. So someone reach out to me and we'll certainly get it up. All right. We're going to go to Judge Middleton.
Good morning.
Good morning.
Are you Teresa Bradley?
Yes, I am.
All right, very good. This is Judge Middleton. You're in the right place. We
Great.
have about 1 minute until we're set to begin. I saw that you'd practiced logging in. I appreciate that.
Yes, I've never done this before, and
Well,
I'm
some
not very
people
good at
practice
this stuff.
1 minute before it starts, but you're doing fine. I can see you and hear you, and your microphone is turned on. And Zoom wasn't a thing till a few years ago. Now it's ubiquitous.
Yeah. Very nice. I just worked all night and just got home, so it's nice to be able to do it in your own home.
Yes, that is the upside of it. There's some downsides, but you won't have to drive to Centerville, and we can take care of our business here,
Yes.
which is a bit odd. All right, it is 8:30. I'm going to call this case.
Okay.
Settled Teresa Bradley versus Jessica Beal, Apartment A and Apartment B. Is this a duplex?
Yes, it is.
There is no lease. Is she related to you?
She's my daughter, and my 4 grandchildren also live there. It's a
I think she's here.
2-bedroom. Okay. It's a 2-bedroom, so it's very small for a mom and 4 children. She's actually in my kitchen on her phone.
Oh, good. I didn't know if I was in the right room. I'm gonna go home.
All right.
Okay.
Are you Jessica Beal?
I am. Sorry, my Zoom isn't working on my mobile device.
All right, we'll make it work. You're the other Jessica Beal. It's spelled Beal.
Yeah.
This is a
That's
termination of
there.
tenancy case that the landlord, who's your mother, wants you to move. So I'm going to take a minute and tell you what your rights are as a tenant. I have to do this in each case, and which is all right. As a defendant in a termination of tenancy case, you have the following legal rights. You have the right to obtain representation, meaning counsel for this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you, and she should be joining us here shortly. There is no court-appointed counsel in civil cases like landlord-tenant. You have a right to a trial by a jury or by the court. If you do demand a jury trial, you have to do it today or do it within 5 days in writing and pay the jury demand fee of $50 unless the judge waives it. You have a right to have your case heard here in St. Joseph County where the property is. This is not about paying rent. This is about moving. If you're able to reach an agreement with your landlord, meaning the case would be dismissed, we could help you prepare a conditional order of dismissal. And if both parties are interested, we could refer the matter to mediation for an attempted settlement. This is a family situation. I've had a number of these lately. I've probably had 25 or more of these this year, where grandmother, grandson, father, son, brother, there's no lease, they're living there, and the other party wants their property back. So Ms. Bradley, you're simply requesting that she move?
That's correct. And she's actually just found housing has come available. So that was a question that I also had. I don't want to mess up her ability to get this 3-bedroom apartment that is coming up. But should that fall through, I just wanted to, I didn't know what I should do. So that's why I was trying to do it this way. Just so there is that as well. So I think that
All right,
we
well,
are getting somewhere.
Where's the apartment, Miss Beal? It's very hard to find. And
They're very
there's a
hard to
waiting
find.
list at Enchanted Glen and other places. Well, here's the story here. The law requires that I adjourn this at least 7 days, which would take us to next Friday, the 25th of October. Then you get 10 more days after that, which would take it to November 4th. So if you move, she can simply dismiss the case But I think our safest bet for now is to adjourn this matter for 1 week.
Yeah.
Yes, because I don't have, they've only verbally promised me the apartment. I've been on this waiting list for 1 year. I have been desperately working to build a business while also living with chronic illness as a single mom of 4 children. And I am doing everything that I can do. There is no housing available. There is no way that I can go and work for someone else when I can charge $300 online as a best-selling author and a publisher and a life coach and a business strategist. But building a business takes time, and my mom is frustrated with that. I have given her money, copious thousands of dollars anytime that I have money. So I'm not in a hurry to move out. I'm fine with taking this to trial. I'm fine with buying as much time as I have to protect my children and I until I can find safe and affordable housing for myself and my family. Because the other option is that I'm living in my car.
Yes, and that's often the problem. The parents or grandparents or siblings aren't required to provide free housing to their kids. It's often a tough situation. Sometimes the family, they want to sell the house and they need to get the people out of there. And that's what this landlord-tenant, it's called summary proceedings, is about. Basically, it's the judge forces you to move out or the sheriff will do it. But I do feel your pain. Good morning, sir.
Good morning.
Let's just have a seat. Every week, twice a week, Monday and Friday, people tell me I would move out if I had somewhere to go to.
Right.
Particularly if you don't have any money. So
Yeah.
the first thing we're going to do is we're going to continue this to next Friday. Miss Bradley, the law requires this. It didn't used to, but when COVID hit, they changed all the rules. So you have to grant one at least 7-day adjournment. So I'm going to continue this to October 25th, 2024 at 10 a.m.
Okay.
for the second hearing. At that time, Miss Beal, I would have to give you at least 10 days to move. And if you didn't move by that date, then the sheriff could come put you out. That's if your mother got what she asked for. Let me ask a couple of questions. Is this a duplex?
Yes,
Who's paying the utilities?
I am.
Well, actually, I'm paying the utilities, and then the utilities on her side weren't paid for, and the water pump is
In
on
my
that
name.
side. So I
So,
had
yeah.
They were in
to
my
pay,
name
All
though.
right, so.
and then I put it in my name. So they're both in my name, and right now she currently told
But
me
I've
that she's
still
not
been
paid
paying
for
it.
it.
Just a minute. Only one
did.
person can talk at a time. So Teresa, you're paying the utilities?
Yes.
No,
Is
Mom,
there any
that's a
rent?
lie. You have never paid
All right.
my utilities in 3 years.
Jessica, I'm paying my
All right,
utilities.
Mom, you're lying.
Stop. I'm embarrassed for both of you. Jessica, you're gonna need to move out of your mother's house. That's just as way it is gonna be.
I know.
So I don't have a
I'm
better.
paying my utilities. I have proof that I'm paying my utilities.
Well, this is not about payment. It's about termination of tenancy. There is no lease. And the plaintiff gave you a notice to quit quite some time ago, back in July, saying that they wanted the property back. And they gave you until August and you didn't move, and then they filed this action. So this didn't just sneak up on everybody. It's been in the offing for a number of months. And this
Well, you asked who's
process.
paying utilities and she just lied.
All right, well, all right.
And I have proof that I'm paying my utilities.
All right, why don't you bring that with you next week?
Absolutely.
All right, at any rate, I guess I don't need to step on any more landmines. We're just gonna deal with this next Friday, October 25th at 10 a.m. And at that point, unless there's some other defense or something I don't know about, Ms. Beal, you're gonna have 10 days from that day to move. So we'll discuss this further next Friday. All right, thank you.
Thank you.
Judge Mills in there never let any of that phase him. I love how he let them know that they're both embarrassing. What a mess. ATX, you had made a comment about it being in your name and paying the bills is a completely different thing. Absolutely. There was another court I was watching today. I'm trying to think of where it was, where every time the judge would ask a question, I think it was Judge Fleischer. Yeah, he was asking about, did you have a diploma? And the person wanted to go on a rant, and he's like, no, I just asked you if you had a high school diploma. And then goes down the list. People need to learn to just simply answer the damn questions. Just answer the questions. Answer what's asked. I have a bad habit of doing that, and it aggravates a lot of employees, aggravates a lot of people. Is I don't offer information that wasn't asked, and people tend to feel that that's being standoffish. When to me, no, I'm just not getting myself into something I don't want to get into. And so, let's jump over to Judge Ricky. This one's quite emotional. This one's got some sad parts in it, and we'll play some goofball stuff in a little bit. We'll play some more lighthearted stuff that's not going to be as serious. But this Judge Ricky one's it's a good one. It's a good one to see. It's a sentencing hearing. So here we go with that.
Fowler, where are you currently situated?
KDOC.
Okay, what facility?
The Topeka Correctional Facility.
Very well, thank you. This matter comes before the court at this time for sentencing. Court's docket notes indicate that the defendant appeared before this court on August the 16th of 2024. At that time, defendant pled guilty to an amended count 1, possession of fentanyl, a level 5 drug felony. A pre-sentence report was ordered, sentencing set for today. Court has received a pre-sentence investigation report compiled by Kit Russell, pre-sentence investigator. He is not currently present on the meeting. I trust each attorney has received a copy of the report, and I'll ask the state's attorney first. Is there any objection to the criminal history, which is stated in the report?
No, Your Honor, no objection to the criminal history.
Is there any objection by the defense, Mr. Watts? You're muted, so if you're trying to talk, I can't hear you.
No, Your Honor. Well, I've not consulted with Ms. Fowler as she just came on. The one item that's a felony that she would make her a G is the item that she is currently serving a probation revocation on. So I don't think there's any doubt about it. So no objection.
All right. Hearing no objection, the court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score G, and the court will proceed accordingly. Mr. Sweeney, are you aware of any legal reason why sentence should not be pronounced in the Fowler case here today?
No, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, sir.
Ms. Fowler, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing today?
No, Your Honor.
Court will proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion which has been filed and needs to be addressed. Does the state have any such motions to pursue?
None, Your Honor.
Does the defense, Mr. Watts?
No, sir.
Are there any victims or members of the victim's family who desires to address the court in relation to this sentencing? I notice I have some other participants on the meeting that were apparently invited by someone.
Yes, Your Honor.
Okay, who is speaking?
Sarah McKee.
Okay. Ms. McKee, what is your relationship to the victim in this case?
I am his sister.
All right. You may make your statement to the court at this time.
On October 26, 2022, you went to Wichita and obtained drugs such as fentanyl. In the early morning on August 27th, 2022, I lost my brother, my best friend. As I watched his lifeless body laying on the garage floor being worked on by paramedics, he died from an overdose. You had given him fentanyl, the same drug that you, being a habitual drug user for years, know can cause death. You did not use life-saving measures such as Narcan, something that you knew how to obtain. You did all of this several feet from his children. A father was lost that day. I do not feel sorry for you. Instead, I feel sorry for the victims, my brother, his children, my parents, my sister, his brother-in-laws. You had a choice many years ago not to use drugs. You have had several chances to get clean and not use drugs, but you still used, have done all of this knowing the causes and effect of what drug use can do. You have not been a good member of society. Because of your recklessness, I'm going to spend the rest of my life without my brother, without my best friend.
Very well. Thank you, Ms. McKee. Are there any other victims' family members who desires to address the court in relation to this sentencing?
Your Honor, I do.
Okay. And your name, sir?
Brad Meyer.
Okay. And your relationship to the victim in this case?
Simon's brother-in-law.
You may address the court with your statement at this time.
I'm reading this today with a heavy heart and a deep sense of sorrow to share the impact of a tragic loss of my brother-in-law, Simon Shippers. Simon was killed by a lethal dose of fentanyl given by you, Terry Fowler, on August the 27th, 2022. As we navigate through this incredibly challenging time, I feel it's crucial to express the profound effects this devastating event you created has had on our lives, particularly my nephews, Shiloh and Silas Shippers. The loss of Simon has left an irreplaceable void in our family. He was not only a beloved brother, son, and brother-in-law, he was also a very devoted father to two very young boys. Their innocence was shattered that night while you allowed their father to lie dying in the garage floor while they slept in their beds only feet away. While they were very young now, not knowing and totally comprehending the enormity of losing their father as a direct result of such a senseless act, they will never get to know just how great their father actually was. Simon touched so many lives being a master of his trade. Simon was an artist, and it shows in both boys every single day. Simon always took time out of his busy schedule to make sure the boys always had what they needed, which often meant working late into the night to make sure of that. While I never saw you work much at all, or much less into the night. Witnessing their pain and their confusion has been heart-wrenching for all of us. As the only family my nephews have left, our whole family has quickly adapted to having them in our home and providing them with the stability, the love, and the support amidst our own grief. We're committed to ensuring that they have a safe, nurturing environment to grow up in, but the emotional toll of this responsibility is immense. We're haunted daily by your senseless act that took Simon's life. Moreover, you knew the effects of your actions and chose to make a trip to Wichita that very evening to get the fentanyl that would ultimately kill Simon and take him from his boys. The trauma of his death has left deep scars within our family that will never, ever heal. The boys are in a great place now, but no thanks to you. As a family, we talk daily about Simon. We talk about it with the boys, even if it's just to say, you're acting just like your dad. To which they will respond and laugh and go right on doing what they were doing. But the boys may never say anything about you. They never talk about you. They never ask about you. I believe that fateful night in August, they lost both parents. Boys won't hesitate to tell someone that their dad did this or their dad did that. Or they remember doing this or that with their dad, but they don't talk about you. The boys are doing great in school, including perfect attendance awards and honor roll, when in 2021, they were not doing well. Poor grades, poor attendance, and only got to school when Simon could make sure they got to school because you didn't do those things. They are in several extracurricular activities that brings out their true personalities, which you would never do, only being worried about your own deadly desires, while their father worked tirelessly to provide for everyone. Terry, you've done nothing throughout this whole process since the 27th of August, except continue down your deadly path. And it's my prayer daily that your path and their paths never cross again. Because you don't deserve them. You deserve exactly what you've got right now. I could go on and on about what you never did for the boys, but everyone already knows, including the boys. To think about your actions in 2022 will get you little to no jail time in the eyes of the court, and that you will be out walking the streets again, living your deadly lifestyle, while Shiloh, Silas, Sarah, Susan, Charlotte, Darlene, Gerald, and Jake, and I will live forever with the grief and the hole in our lives because of your actions on August the 27th, 2022. It is sickening and disgraceful. Thank you, Your Honor.
Very well. Thank you, Mr. Meyer. Are there any other family members who desire to address the court in relation to this sentencing? Court finds that no other persons desire to address the court to make victims' family statements. So we'll move on at this time to recommendations from legal counsel regarding an appropriate sentence for the defendant, beginning with prosecuting attorney Brett Sweeney on behalf of the state.
Thank you, Your Honor. Your Honor, pursuant to plea agreement, the state is recommending the aggravated box, these 16 months in the Department of Corrections. We're recommending the aggravated box, just given the circumstances and the nature of this offense, which I know the court has heard the preliminary hearing evidence on. Additionally, I would note that this is a second possession offense, and also I think it's worth noting is a second strike, which does have some implications in Kansas law as well. The state's recommending the maximum good time. Well, she would be eligible for a maximum good time percentage of 20%, as well as have a post-release supervision duration of 12 months. Your Honor, as far as the jail time credit goes, I would acknowledge that she has been in custody on this case since January the 18th of 2024. However, I would note that she was revoked from her probation on 23 CR 25 in May of this year. I guess she technically still would have had May 17th. She technically still would have been on bond in this case. And I know there's some recent and relative case law to that, but I just did want to point that out. Additionally, Your Honor, I would note that she's obviously, the court has a PSI in front of it. This is a presumptive probation case, and given her pre-sentencing evaluation scores, she scored one of the highest scores I think I've ever seen on one of these evaluations. But that put her in the mandatory Senate bill position, and so I think it kind of is what it is. The state would acknowledge that she needs to be put on community corrections probation for a period of up to 18 months. And that would include, obviously, the recommendations that are included in the treatment evaluation that's also included in the PSI. That appears to be intensive outpatient treatment with a number of different aftercare components that are involved with that. The state would recommend that all of those be adopted. I would also note that this is not always standard, but there is a mental health treatment component that's being recommended within the PSI as well. I would ask that that be adopted as a condition of probation, although I don't think that that is necessarily covered under the subsidized Senate bill rubric. Additionally, the state's asking for the adoption, of course, of all the conditions within the PSI. One specifically, I would note, is no contact with the co-defendant, Nathan Allen Carr, and then also that she comply with any other court orders and any other cases that she may have ongoing. Your Honor, as far as any other costs and fees, the state is not requesting a fine in this case. We are requesting, of course, the court costs in the matter. There is no DNA. She's got a prior possession that she was revoked on. We are requesting the Senate Bill 123 fee in the amount of $300. And the state would be requesting that the court take a look at attorneys and bids fees if appropriate. And Your Honor, I think with that, that's all I have to offer for the court.
Very well, Mr. Sweeney. Mr. Watts, your recommendations regarding an appropriate sentence?
Thank you, Your Honor. Pursuant to plea agreement in this case, we would join the state's recommendation as to the aggravated box, the upper box, and the grid box of 16 months in the Department of Corrections. As Mr. Sweeney has noted, this is a Senate Bill 123 case. As Mr. Sweeney has also noted, and I've explained to Ms. Fowler as well, as I know she well understands, this is a second of what could be at some point a third strike. So if Ms. Fowler comes back on a third possession of methamphetamines, or third possession of any felony drug, by the way, for that matter, she's looking at a presumptive prison outcome rather than a presumptive probation outcome with the Senate Bill 123, which is where we're at this case. She's currently in the Department of Corrections, as we all know, as she appears from there. It's important to note, however, that her out date for the Department of Corrections at this point is less than a week away. So she can easily step into the Senate Bill 123 treatment program that is called for, and it's certainly called for in this case. Further, while the PSI calls for 236 days of credit, I think that should also include the days up to today pursuant to the recent case law. She went into custody on this case, I think on the July 18, and as far as I know, has never left custody in this particular case. She's been in custody, I think that entire time. Certainly we seem to reflect that. Now, I understand she's been in the Department of Corrections custody as well, part of that time, but pursuant to the current case law, the most recent case law, I don't think that means she cannot get credit for those days. By my math, she would get 274 days, which would be the 38 days from September 10 to today's date. Judge, I think I should just leave it at that.
And Your Honor, if I may piggyback on that just very briefly.
You may.
I mean, I think that's accurate on the jail time credit to the extent that the court doesn't run these two cases consecutive. Certainly, if this case was run consecutive to that case, then she's only going to get credit for jail time credit in one case. And I think the court's aware of that. I just wanted to throw that out there.
And I agree, Your Honor, that would be correct should the court run them consecutive.
All right. I have Jessica Morgan here from the Court Services Department, and I realize, Ms. Morgan, you didn't compile this report, but why did Mr. Russell stop the jail time credit running as of September the 10th? Do you know?
Your Honor, I have I am not aware of why he stopped it on September 10th, and there's no information in the PSI or in the file. So I apologize, Your Honor.
No, that's all right. Just thought if you had some explanatory information that you could provide it to the court, but I certainly understand. All right, very well then. Mr. Watts, what are your fees in the representation of this client?
Your Honor, this was billed to bids at $2,400.
All right, thank you.
And I'll note, Your Honor, what I'm sure the court has assumed, and I think is correct, that September 10 date was her admission date to the Department of Corrections.
At this time, the court will address the defendant, Olga Terry Fowler, personally, and I'll ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to present to the court. Ms. Fowler?
Right before I was arrested, I completed inpatient. The PSI that you guys are looking at was completed before on my first possession felony. I tried to get a new PSI to you guys, but I was brought to KDOC and I couldn't get the paperwork. What happened that night was horrible. And I don't deny that part of it was my fault, but I live with that every day. I don't have my kids. And I know what I felt. I'm sorry. I don't know what else to say.
Very well, Ms. Fowler. Court will pronounce sentence in this case at this time. Court hereby establishes count 1 as the base sentence in this case for the offense of possession of fentanyl, a severity level 5 drug, non-person felony, which the defendant has a criminal history score of G, thus placing her in grid box 5, drug G. The court hereby sentences the defendant to the aggravated term of 16 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. Court has considered but declines to impose a fine in this particular case. Regardless of what this court may feel the appropriate sentence is in this case, Ms. Fowler, the court is constrained here. The Kansas legislature has determined that someone with your very high risk score on your risk needs assessment, combined with the high probability of you having a substance abuse disorder, means that you are mandatorily to be granted probation as part of a state-sponsored drug treatment program. One could quarrel as to whether that's the appropriate sentence in this case or not, but when the legislature says it's mandatory, according to case law, it means mandatory. So the court will sentence you at this time to a drug treatment program until deemed suitable for discharge for up to 18 months, with up to 18 months probation to be supervised by the Community Corrections Department. Conditions of that probation will include reporting to an officer as directed, observing all laws. You must appropriately complete alcohol and drug treatment in connection with your Senate Bill 123 evaluation and assessments, and follow the recommendations of your drug treatment counselors. You will also obtain an assessment for mental health, and the court is going to require that that mental health assessment be done within 45 days of the date of your release from custody. Then you must comply with any mental health treatment recommendations made by your evaluator. At your supervising officer's request and at your own expense, you shall submit to random breath, blood, and urinalysis testing, perform community service work pursuant to program requirements, gain and maintain employment suitably throughout your probationary term, notify your ISO within 24 hours of any change in employment status, residence, telephone number, email address, or any contact with law enforcement. You shall have no contact with the co-defendant, Nathan Allen Carr, currently in case number 2023 CR 307. You shall abide by any curfew or travel restrictions imposed by your officer. Follow all standard conditions of community corrections probation, not have in your possession firearms or dangerous weapons, and avoid disreputable characters and places. Ms. Fowler, some people leave the court at sentencing without a faintest idea as to what disreputable characters and places means. Disreputable characters would be anyone who would expose you to any type of illegal drugs, pure and simple. And disreputable places is anywhere where you might be, where those people are. You'll need to govern your behavior accordingly. You shall also make monthly payments on your obligations in a manner acceptable to the court. The court will be assessing a felony docket fee, felony probation fee, community corrections fee, $300 reimbursement to the Senate Bill 123 treatment program. Bids or assessments are waived given the defendant's incarcerated status currently. The court does not have adequate information in which to base bids orders, though obviously legal services have been very valuable to her. Court must waive those at this juncture. Ms. Fowler, once you're out, I'm going to require you to pay at least $100 a month on your obligations. I don't think that modest amount is going to work a burden or hardship on you or any member of your family once you're out and working. And that will start with the first full calendar month after you get out of custody. And every subsequent month until your case is paid in full. Regarding the issue of jail time credit, the court will be awarding the defendant what the court computes to be 274 days, making a slight adjustment to the jail time credit figure that's on the face sheet of the pre-sentence report. Court will be awarding 274 days credit in this case. I don't believe that there was an actual request for restitution here of any kind. Is there, Mr. Sweeney?
No, Your Honor. My understanding is there's no dollar amount that's being requested.
All right. Ms. Fowler, I'll inform you that criminal defendants under certain circumstances have the right to appeal a conviction to an appellate court having jurisdiction. If they are unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal, and that they be to direct that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. And you do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Furthermore, Ms. Fowler, it's not the responsibility of a community corrections officer to chase you down after you're released from custody, but rather your responsibility to contact the community corrections department the first day that you are out. So I do have Marcy Taronas, an ISO with Community Corrections, on this meeting. I don't have a lot of time, Marcy, but we can leave the meeting open so that you can confer privately with Ms. Fowler and give her some direction as to what else she needs to do to get started on her community corrections upon whatever release date she has. So Ms. Fowler, stay on the meeting a little longer after I recess so the ISO can talk to you, okay?
Okay.
All right. Mr. Sweeney, were there any other sentencing related matters that the court needs to address?
Not from the state, Your Honor.
Mr. Watts, is there anything further that the court needs to address?
I don't believe so, Your Honor. Thank you.
Ms. Fowler, do you have any questions regarding the court sentencing orders?
No, Your Honor.
You cannot come back, Ms. Fowler. You have one opportunity to take advantage of the state's sponsored treatment program and successfully complete this community corrections probation. Do not leave here today thinking that you're going to get multiple opportunities to be successful. You have this opportunity today. Seize it. And once and for all, break this grip that drugs has on you and your life with the toll that it takes not only on you, but everyone around you. Good luck, Ms. Fowler. I hope you're successful. If there's nothing further then, the Olga Terry Fowler matter will currently be in recess, and this meeting may be ended for all.
Good afternoon, Your Honor. Good afternoon.
All right, I'm going to go in and say some stuff I normally don't want to say. That sentencing hearing was kind of crummy. There's some speculation needed for what I'm going to say, so everybody just understand I don't know anything about that case. I don't know anything about those people. Drug users are victims themselves. They create other victims, but they're also victims themselves. And she I don't know, they mentioned what type of mind state she was in when he died, but you also got to think about the Sarah Boone case going on. She's so damn goofy. She gave the police the tape of her of her not letting him out of the suitcase, and him ended up dying that night. This lady's a disaster. She's lost her kids, and hopefully the kids have a better life. If it's with her in 5 years, once she gets her life straight and becomes a better person, great. But right now she's in a bad spot, and I hate it for the victim impact statement because they described a horrible thing, and the sentence didn't seem to reflect a horrible thing. But the charges were not the same. This is a mess. But I got a comment. We got a guy in here that's hitting on Linus pretty hard. Linus is trying to come to Houston. You wanna shoot your shot. Go into GoFundMe and impress her. Do something that's going to impress her. For the rest of us, if you got something to show you support for her, do what you can. If you can't, just be nice to everybody. That's the best we can hope for. Earlier we were talking about some of the chats, and we were just talking about how nice chats can be if people start off by being nice and people continue being nice in it. So don't come into these being nasty. Bodie, you got a lot of good questions on this one, because I agree with you on, I think 99% of what you're saying. I think you're hitting a lot of good topics on there, but it may just be me. Pay up, man, and impress Linus and get her here to Texas. You know what? Go in and double the money that's there. That's a challenge to you. Win her heart over. There she goes. She's saying win her heart. And hell, you pay enough money, I'll go out with you in Houston. So just keep throwing some money in there, buddy. We're going to go over to some Judge Fleischer from today. And then at 9:30, we're going to jump over and do Court Addict. And we're going to have ATX Alley on there. And ATX Alley is a good person. She had a bad spell with some trouble in the past, but that also gives her a little bit better perspective. You think about like the fentanyl and stuff, and of course it's simple. Just stay away from it. Just don't go near it. Just, stay the hell away from it. But there's also the perspective of, do you even know when you're getting it? You may think you're just smoking weed or something, and all of a sudden you've got a damn fentanyl habit. So I don't know how that works. Ask her. We'll be doing it in about 30 minutes. So we're going to jump to some Judge Fleischer, and let's see how it goes.
We're waiting on the Spanish interpreter for council. So next is page 4, Tomie Jacoby. You swear that you will not pursue your legal without bounds to serve the license and the approval.
Vic, what page?
4, top of page 4.
Got it. Stephen, I need your help. Mr. Cormier, right?
Yes, sir.
You have 2 felony warrants for your arrest now. 2 felony warrants for aggravated assault with a deadly weapon, 1 for aggravated assault of a family member, 1 for aggravated assault with a deadly weapon. You've made bond on our interference case, but it looks like they just filed on 10/10, which was about 8 days ago, 2 felony assault cases, so we have to take you into custody. You do have a lawyer coming today?
Yes.
Okay, so what we're going to do is we're just going to verify that the warrants are valid. If they are valid, I have to take you into custody. You're being held at that right now at no bond. So at some point you'll get in front of a magistrate, and I don't know if they'll set you a bond, but I'll have you talk to your lawyer today as well. Okay? Goes with you.
I didn't see one earlier. So.
Hey, Durval, the Linus thing. So Linus V in the chat there, she is one of our moderators. She lives in the Netherlands. She's also a moderator for this judge that you see on the screen right now. She moderates his court Monday through Friday. She does that as a volunteer. She doesn't make any money. She does it just out of her interest for it. And in the end, just, I guess you call it civic duties, just being a good person. The judge wanted to be able to have a live stream and wanted to be able to have a chat, but needed to be able to keep it managed, needed to be able to keep it safe and clean and a welcoming place for everybody. He wanted a chat that didn't have the defendants getting made fun of. He didn't have, people being made fun of while they're in a bad situation in court. And Lena stepped up to the plate, and she's been helping out with that. She's been doing a great job with that. Kathy with Court Vibes, I believe she set it up. If not, she was very instrumental in it working out. And Kathy trusted Linus with it. The people at the court trusted Linus with it. And she's been great, great help on there. And so we set up a thing to get her to the U.S. To go visit Houston, go visit the court, and go visit, just go visit Houston. She's going to go see NASA and all that. And so we'd set up a GoFundMe, and that's where that is. This channel is not good at begging for money online, and we don't want to ever be good with begging for money. But this is a good story. This is a good case for it. This is a good reason to hit people up for money. The money is going directly to her. There's no middleman involved. I didn't trust GoFundMe whenever we set it up. I didn't trust it because, I don't want them to get 30-40%, but the number is 3% is what they get. And that's a very reasonable number that, that covers the credit card charges and the processing charges. But I don't mind donating money if I know 97% of it's going to get to the person. I don't want to donate money when it's only 60% getting to them. So let's get back into this so we can get on track. But thanks for the question, Deval.
All right, page 6.
Do you see 2 felony
Come on
warrants?
up.
Do you see? Yeah, I see 2 felony warrants.
They look like they're not. Page 6, Diaz.
Okay. Are you Tanya? Is it Tanya Diaz? Ms. Tanya Diaz, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Officers were dispatched to a Walmart in Harris County, Texas, in response to an assault. The complainant stated he was working on a construction project in the Walmart parking lot and was directing traffic. The defendant became upset because he directed her to go around the construction site. The defendant got out of her car, yelled at the complainant. A few minutes later, the defendant returned and began arguing with the complainant. The complainant began recording the defendant on his phone, and the defendant hit the complainant's hand, leading him to hit his cheek with his phone, causing pain. Parking spot, got it.
Yes, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. not to be in possession of any weapons, and not to go back to this Walmart. Do you understand?
Yes, sir.
If you violate any of these conditions, I will revoke your bond, put you in jail. You will not get any more PR bonds. Tell me, what do you do for a living, man?
What I do?
Yes.
I'm a handicapped person, and I try to get my parking. I'm waiting for
Okay,
somebody.
I don't want to talk about the case. Do you have the ability to hire a lawyer?
No, I don't have a job right now. I'm gonna start working today.
How do you support yourself?
I have an unemployment paycheck, and I'm doing Uber Eats sometimes because my car is not in good conditions.
Sorry?
My car is not in good condition.
Are you married?
I'm married, but he left me 4 years ago. My husband.
You said 4 years ago?
Yes, sir.
Okay. Did you want to apply for a court-appointed lawyer, man?
Yes.
Okay. Let me make sure we don't have it in the file. This is what we're going to do. I'm going to have you, we're going to give you an application for an appointed lawyer and have you go to Victoria, sign a reset. After that, I'll have you take a seat in the jury box. Do not leave until you sign our bond conditions prohibiting you from going to this Walmart, no weapons and no contact with this person. Okay? Tell me, do you have a Texas driver license?
Yes, sir.
You do? Okay. All right, please. So can you file all those conditions, please?
Chavez, David?
You just want a normal reset? Are you going to represent him upstairs?
When those cases become active, they're not active cases.
Your Honor,
Okay.
they're not open warrants at this moment. There's some, looks like possibly a judge is waiting to sign on, but they're not active warrants, so that's why he's back
Judges,
in
I'm
the legal
waiting,
box.
the hearing officer didn't sign the complaint to me, so that's why it's still going on the warrant steps.
What is that? What is his name again?
Mr. Cormier is the last name.
It's the 248, Your Honor.
Is that, Unger? Since you guys are here, do you want me to just have her sign it?
I would prefer her to read it and see if she's gonna get to PC or not on the case.
Well, that, I meant,
Yeah.
of course, that's what I meant.
Yes.
Like, because for her to read the 2B, to sign it, whether she's going to or not, since you're here.
I mean, they're in trial right now. That's the other issue. So like I've been up there.
You see, it looked like Mr. Cormier has 2 felony warrants for an ag assault and ag assault with a deadly weapon, but they haven't been signed.
Interesting. When did they get filed?
10/10. Today's 18th, so they've been pending for.
I don't know what to say.
You mind bringing him out?
He's in the box.
Come up, Mr. Cormier. I mean, I'm showing the ag assault is active though.
Because in the system, it will show that because it was filed, but the actual arrest warrant has not been signed by a judge establishing that there's probable cause for his arrest.
Judge, in J-Web, it doesn't reflect the open.
Right.
And he actually got arrested and they let him out of jail because of this issue. And the magistrate obviously reviewed that.
Crazy
as well.
I mean,
Yeah.
This is.
Judge, we're gonna contact Intech to see what the issue may or may not be at this point. Hold up, we're doing that right now.
While you guys are doing that, we're going to do probable cause in our case. Mr. Cormier, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 4th, 2024, officers conducted a traffic stop for the defendant failing to signal when changing lanes. The officer made contact with the defendant and told him why he was pulled over. The officer identified him with his driver's license and ran the defendant and discovered the defendant had multiple warrants. The officer asked the defendant to step out of the vehicle multiple times, but the defendant continued to ask why. The officer told the defendant if he did not comply, he would be removed from the vehicle, which the defendant replied, "I guess we can try that shit." The defendant eventually stepped out of the vehicle, but the officer attempted to detain him, and the defendant kept pulling his hands away from the officers and kept trying to turn around so the officers could not place handcuffs on him. The officer eventually detained the defendant and walked him over to the patrol vehicle, but the officers had to use force to get the defendant inside the back of the unit, due to the defendant using his body and the door frame to actively push away from the patrol unit.
What happened with the felony cases? I'd like to know how dangerous of a person Mr. Cormier is.
Yes, Your Honor. We have on October 9th, 2024, the officers were dispatched to a shooting call at a residence. The officers met with the complainant, who stated he got into an argument with the defendant that turned into a fight. The next day, the complainant got into an argument with the defendant's father that turned into a fight, but that was later reconciled. The defendant, however, was still angry and told the complainant that he wanted to fight, pulled a pistol out of his waistband, pointed at the complainant, and discharged the pistol. The shot missed, and the defendant
discharged a pistol pointing at someone?
Yes, Your Honor. And then following the shot missing, the defendant ran away, and a 3-year-old child was in the vicinity of the complainant where the shot was pointed at, and the mother is a witness to the events.
Is that part and parcel with the deadly weapon as well, or is that a different?
It is. One moment, Your Honor. It's part and parcel, Your Honor.
All right. Mr. Cormier, I'm going to find that there's probable cause to go forward with your case. In our case, I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. You have a Texas driver license. You are not allowed to drive. If I find that you drive, I will have a contempt hearing. You'll be facing an additional 6 months. I'm going to have you sign an affidavit with me today promising you're not going to drive. Do you understand? If you want to drive, go get a license, get liability insurance, and then I can take this off. But until that point, do not drive. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're consuming alcohol or any kind of dope, I'm going to put you in jail. Do you understand? Let me make something perfectly clear to you. I'm going to do everything in my power to protect every person of Harris County. If I find that you become a danger, I'm going to revoke your bond and I'm going to make it sky high. Do you understand?
Sir.
On this affidavit, I'm also going to have that you are not to be in possession of any weapons. If I find that you have a weapon, likewise, I will have a contempt hearing. Do you understand? So I don't know what's going to happen now. I want to see what they say first about, because Mr. Living, he scares me.
If that is
You
just
know?
at this point in time, there is no warrant.
I get it,
So
but I don't know what,
holding him in a courtroom with no warrant is kind of my issue with it, if that makes sense.
I get it. So here's what I'm going to do. I'm going to send him for a drug test. I want to know what, if anything, he has in his system, and then I'm going to have him come right back.
Okay.
You need to go take a drug test right now, and then you must come back. If you fail to go take the drug test, if you fail to come back, I'm going to issue a warrant for your arrest. And I'm going to tell you now, no more PR bonds. Do you understand? Okay. Come on.
Page 13, Martinez,
15.
13.
Angie Martinez. Ms. Martinez, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On October 12th, 2024, the officer was dispatched to an assault. The complainant, the defendant's spouse, stated that he was watching a sports game when the defendant started verbally arguing with him and hit him with her hand. The complainant reflexively hit the defendant with his hand. Then the defendant hit him with a full beer can in the face. The officer observed swelling around the complainant's right eye and nose, and the officer noted signs of intoxication from both parties.
To have contact with her.
Your Honor, let me see if the rip was performed. It was. Let me see real quick.
And did you talk to this person, the complaining witness by chance, Ms. Martinez's case?
Your Honor, this is a domestic violence case, a DVD case, so.
So, hey, you're here. This is Angie Martinez. Thank you for being here. So my question to you is, do we know whether he wants to continue to have contact with her or not?
I do, Judge. I spoke with him this morning. He asked that there be contact, as well as the residency restriction removed so that she can return to the house.
Prior assault that she has, it's not against him, is it?
No, Judge.
Okay, Ms. Martinez, like I said, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs, I will put you in jail. You will not get any more PR bonds. Do you understand? It appears that on the 13th, they issued a protective order in this case. I would get to know it. If you do something to violate that protective order, the state can and will file additional charges against you, and then things will go sideways real quick. Get to know it. Do not violate the protective order in any way. I am ordering you not to have any threatening or harassing contact with the complaining witness in this case. You need to understand that what is threatening or harassing doesn't matter what you think. We could care less what you think, how you feel. It's what he perceives. So can conduct in and of itself, if I go like this, is that threatening or harassing? It is. So conduct, even without spoken word, can violate this court order. Do you understand? As long as you don't consume alcohol or illegal drugs, hopefully that will be the end of it. I saw Mr. Wytek here earlier.
He is here.
Did you talk to him at all or no?
Yes.
Okay. Did you get a date from him?
No, I'll just wait for him to come back.
So yeah, we'll wait for him to come back. So at this time, I'm going to have you sign a reset with Victoria. After that, we'll have you take your seat in the jury box. Can you file no threatening, harassing, and no weapons, please?
Yes, Judge.
We're going to have you sign these bond conditions as well. Well, you know what? Don't worry about it because she's going to be monitored. You don't need to do it. We'll do it through pretrial.
Yes, Judge.
We'll have you then meet with pretrial, and then we'll have you wait for your lawyer to get here. Okay?
Thank you, Judge.
Oh, yeah. You want to print me up the law?
Line was here earlier and approached for him.
Yeah.
I think Your Honor sent him to do a drug test. I believe those results came back negative.
Okay, come up, sir. Did intake say anything about this case?
They couldn't tell why it wasn't signed correctly, Judge. I asked the 248 if they had time to approach their judge this morning about the PC, and I have not heard back, so. We can certainly take it into grand jury or go upstairs.
Well, no, what I'm going to do is I'm going to put a whole host of conditions on him. You know, I'm going to tell you now, you're lucky that you're here. You know, one false move in this very short life that we have, you could be spending the next 40 to 50 years of your life in a 6x9 box. One false move. It is a real travesty that a lot of people have guns and there's just no need. You know, when you use and when you have something like that, a short second, you can kill someone. And when that happens, your life's over. Multiple lives are over. Multiple families are over in the short second of something so stupid as an argument. When you make a decision like that, it's a lifetime decision that you can never crawl out of, never walk away from. Think before you act. Sometimes you have but a nanosecond to do it. But I'm going to tell you now, Mr. Cormier, I'm going to do everything in my power to protect the public. Do you understand? I'm putting a GPS monitor and I don't want you out in the middle of the night. Do you understand? You have a weapon. You pick up any type of weapon, I will have a contempt hearing. You'll be facing an additional 6 months every single time. Do you understand? Because it's an offense in and of itself. I had him sign an affidavit that he's not supposed to have any weapons.
Yes, Your Honor.
And I'm going to give him a curfew, and I don't want him to hang out with any bad, irreputable people. No. What are you doing with yourself now? Are you working, going to school?
I work.
Where?
Oh, for Port Houston.
Doing what?
Operator.
What are your hours?
7 to 9.
Okay, you have a 10 p.m. curfew. Do you understand? 10 PM to, you said what time you work? 6? 7? Okay, 6 AM.
6 a.m.
10 to 6 AM is your curfew. You must charge this thing on a daily basis. If the battery goes dead, so does your bond. Do you understand? All right. Okay.
Thank you, Judge.
I would be on the lookout because I'm telling you now, it's just a moment's notice before you get hit with 2 felony warrants. So you better be on the lookout. It's going to happen any minute. Gets the device today. Okay. All right. Okay, guys. Thanks.
How much time?
Oh, reset.
Yeah, the case is 250 days old. So I'll give you 30 days now. But at that time, you got to come back. You got to tell us what you want to do. We set cases for trial at 180 days. Your case is now 200 and what?
57 days.
Yeah, you have 30 days. At that time, you got to be back here and let me know what you want to do. You must either accept a plea bargain agreement or I'm going to set your case for trial. Do you understand? Okay,
Is discovery complete and are there any offers?
Steph,
To be honest with you, Your Honor, I don't believe I've looked at the
I
discovery.
know that you haven't looked at it, but
Looking at it, Judge, it does look like discovery is complete. I can put a rec on it. Steph.
please, okay, done.
All right, thanks, Judge.
Come on, it's time to go play Fortnite. Let's go. Come on. Huh? Come on, man. I'm itching to
Give me
go
approach,
play.
Judge. We're approaching on Mr. Wiggins. He's in custody.
Okay, Sterling,
Yes.
whatever happened with Mr. Wiggins?
Well, Mr. Wiggins has some bond conditions to not speak to a complaining witness in an ag assault with a deadly weapon and an ag assault family member. He then went to jail and called her twice and her mom.
I mean, what more can we do? Really?
Take the phone away.
Oh, yeah, that's a good point. We'll do it now.
He also called not only under his own name, but he also called under 3 other inmates' names.
Have you alerted the felony courts?
I just found out about this. The deputy actually called all of us to let us know that this happened.
Guys. Oh,
You want me to do something, Judge? You want to-
yeah. Do you mind bringing out Mr. Wiggins, please? Sterling Wiggins. I'm going to take his phone privileges away now.
Okay, and Judge, these are serious allegations, but I need to point out that Mr. Wiggins is 19 and you're also taking away his ability to communicate with his family.
We told him not to do it. He's doing it. I mean, what else can he's pull the records. Is he trying to thwart it? Pull the phone records. If he's trying to thwart it, then you get him with an obstruction.
The deputy is going through Ferris to get transcripts of the calls, so we will have those transcripts soon. The deputy just called me and let me know that the defendant was contacting the complainant and her mother and saying that this is how you take care of things and that everybody violates their bond conditions. And
let's hold on. Wait till he's out here so he can hear this. Good morning, Mr. Wiggins.
Morning.
How's jail?
Cool.
It's come to my attention that you are violating the conditions that we set out in this court, flaunting it and trying to get a hold of the complaining witnesses in these cases when we've told you not to. Go ahead.
yes, Judge, the deputy called me this morning and said that the defendant has called the complaining witness twice and the mother of the complaining witness as well. The deputy told me that while listening to these phone calls, he heard the defendant and say things such as, this is how you take care of things, and that everybody violates their bond conditions and talks to the complainants in these cases. He also heard the defendant make statements saying that he was going to continue to violate bond, and once he gets out, he was going to hire an attorney, but he had previously learned that the defendant was indigent, and so he took this to mean that the defendant was going to commit other criminal acts to get money to hire an attorney.
Can you please notify the other courts as well that are so that they know as well?
Yes, Judge. I just sent a full email to the felony prosecutor in case the deputy hadn't already alerted her. I just went ahead and did it. The deputy, again, is getting the transcripts for these calls, and that the defendant has been using 3 separate inmate spin codes. That would be Jermaine Brown, Mark Diaz, and Dennis Compton.
Your privileges are hereby revoked. You are not allowed to use the jail phone at all from now on. Do you understand? I think that you are continuing to threat to the public even while being in jail. So your privileges to use the phones at all are hereby revoked.
Judge, I just,
She
again,
just told you.
please stop.
So
And I just want to reiterate.
Please, go ahead.
He's
Yeah.
19. You are taking away his ability to communicate with his family.
But he's making additional threats allegedly, you know? Okay, we're gonna get the records, but until I know that you're not a threat, I mean,
He's typing everything.
every single thing that you say on the phone is recorded.
I know that, so why would I be on it threatening people?
We'll find out, because I'm gonna ask, could you mind please pulling all the records, getting all the phone calls, and we'll play them out here in court, and we'll see. And if it's not, then I will gladly give you your phone privileges back, but there have deputies that have pinpointed you allegedly, you and using other people's spin numbers to make phone calls, to make continuing threats, and to further criminality if and when you get out.
What
Well, I don't want you to say anything. That's okay. We're going to find out because I'm going to have them pull all the records, pull all the phone calls, and we'll listen to everything.
Judge, I will also say that the defendant told the complaining witness, this is about the ag assault involving the firearm, that when she got shot, the defendant said that's what happens when you hang out with gangsters.
So pull all that stuff, you know, and all that stuff gets so we need to figure out how, because it's a first for me as far as doing a revocation of privileges like that. As far as revoking phone privileges for inmates,
As far as I know, it has to be through the court order.
okay. I need to do whatever I can because it's apparently a problem now. So I guess I'll reach out to administration as well to figure out how, because I mean, it's a first for me.
Judge, just so we're all on the same page, Mr. Wiggins is obviously going back to the jail now. Even before that order is in place, you are instructing him now not to use the phone. So.
Oh.
So I didn't do it. That's so stupid.
Well, we'll get the tapes and.
Get it? We'll see.
Okay, look, okay, but I can't call nobody, literally nobody. So what? There's no TV in my tank. There's no nothing. What am I supposed to do?
It's jail.
What's the point?
Read a book.
There is no books. I read every book in there.
Yes.
Okay. I can't trust you to use a phone, Mr. Wiggins. I mean, you know what's happening. I have other deputies that have alerted us to what's going on. I can't. That's it. I mean, you got to know when you're in the jail, there are eyes all over you. It's like at a casino. You literally have eyes all over you at all times. You got to know that whatever you're doing is always being looked at.
Stay in bed. That's why I wasn't threatening nobody. I didn't say anything.
He's typing everything you're saying.
Asking him
I
to pull it.
understand. He's talking about I'm doing illegal things when I get out to hire a lawyer and all these other things. That's stupid. I never said anything about anything illegal. That's just.
So I guess let's do this. How long will it take you to get those records, do you think?
I'm actually not sure, Judge. I haven't requested jail calls before like that. Let me ask.
Hey, Steph, how long does it take to get jail calls?
We can put a request in, Judge, to our folks. It can take a little time. I've seen it take anywhere from 30 days to longer, but we can put in the request and see if we can rush it, especially if we have specific calls, which I'm guessing you do.
Yes, and the deputy has already, when I spoke to him, he said he was already gathering transcripts through theirs, so it might already be.
Okay, so let's do this. Let's put it on for next Friday.
Yes, Judge.
Now, if you can get it quicker, let me know. We'll docket them quicker. And then we'll put it off for a week, and then we'll come back in a week and we'll deal with the situation. But okay.
Judge, just, I'm going to be out next week. I can appear on Zoom.
All right, we're going to go ahead and take a pause on that with the scheduling part of it. I know that guy all too well. He thinks everyone's supposed to just cater to him and bow down to him and let him run the show. Man, if he'd take that time in jail and kind of reconsider his life, he'd do himself so much better. And I've never known the prosecutors to lie about the jail calls. It seems like they know about the calls, and they know that they're going to get called on the carpet for him. So he would do himself better just simply saying he was emotional, got caught up in it, and just move along. But he's going to prolong it, and maybe one day he'll grow up. But he's 19, so he's got a lot of growing left to do. Hey, we're going to go ahead and end the show. We're going to jump over to Court Addict over at American Courts 2. It's going to redirect. If you haven't had a chance to subscribe to that channel, do that. Thank you guys so much for being here tonight, and we'll see you next time.